very warmly, and I'm looking at the agenda, and the next speaker is two from Poland, Mr. Bartłomiej Oręziak. He introduces us speech under title Legal Aspects of Censorship in Social Networks, Perspective of the Republic of Poland. Ladies and gentlemen, thank you again. Mr. Bartłomiej Oręziak, please, the floor is yours. Thank you very much.
Okay, thank you very much, dear professor. Welcome, dear sir and madams. This is a great honor for me. So good morning. My name is Bartłomiej Oręziak, and I am a member of the Central European Professors Network, exactly in the group, the impact of digital platforms and social media on freedom of expression and pluralism, headed by Professor Marcin Wielec. I'm also a PhD student at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw, and today I will talk about legal aspects of censorship in social networks. It will be a perspective of the Republic of Poland. Ladies and gentlemen, in Poland, unlawful censorship has pejorative view due to its communist roots. It should therefore come as no surprise that any form of censorship, any form, including this based on law, on digital platforms and social media, is met with a negative public response. The more so, if the basis for such restriction is not a law or a legal standard, but rules of a different kind. For example, some kind of the internet regulations of a specific social networks or other website. Of course, internet user often automatically accepts the content of such internet regulations. But this does not mean that censorship has a basis in Polish law. This is because pursuant to Article 87 of the Constitution of the Republic of Poland, the legitimate sources of law binding in Poland are the Constitution of the Republic of Poland, of course, laws. It means the law is what the Romans called the lex, not use, of course, ratified international agreements, regulations, and in the area of operation of the bodies that establish them, acts of local law. These legal acts may only be issued by constitutionally authorized legal entities, for example, Polish Parliament. Yes. This is one side of the consideration, and the second side is fact that internet regulations created for the functioning of digital platforms, social media, or any other websites certainly have nothing to do with law binding in Poland. This means that it cannot freely create rights, obligations, penalties, nor limit legally created rights of an individual. As is clear from the observation of the internet, in my opinion, of the rules prevailing on the internet, this is generally not the case. The fact is that the currently existing phenomena of control and restriction of internet users' activities, including the publication of content by them, in particular due to political or moral reasons, result from documents of the nature of internet regulations. Rather, the rule is that these documents do not refer to the Polish legal system, in particular due to the transnational nature of the activities of digital platforms or social media. But however, this feature, this transnational nature, cannot justify limiting the freedoms and rights of individuals on the internet provided for in the Polish normative system. Ladies and gentlemen, due to this fact, most of internet regulations specify the application jurisdiction, specify applicable jurisdiction and law. Due to this fact and that the fact that there is currently no legal framework directly concerning neither the legal status of digital platform and social media nor the sanctioning of unlawful censorship in the internet, it can be concluded that this issue is in a specific legal vacuum. Recognizing this fact, Polish Ministry of Justice decided on January 22, 2021 to submit an application to the Chamber of the Prime Minister for an entry in the list of legislative works of the Council of Ministers of the draft act on the protection of freedom of speech and social network websites, hereinafter just draft law. Ladies and gentlemen, this new legislative appears to be a direct response to the regulatory gap that exists. The message seems to be clear. Freedom of expression, of speech, or pluralism are to be guaranteed regardless of the environment in which the individual operates, especially in the digital environment. However, any restriction on the right and freedoms of Polish internet users must be normative, justified in accordance with Polish law. And according to the preamble to the draft law, it is to be adopted due to the special constitutional value of freedom of speech. And in order to strengthen the rule of this freedom in the search of truth, the functioning of a democratic state, and respect for the principle for freedom of expression and human dignity, the Polish Ministry of Justice points out that under draft law, social networking sites will be not able to delete entries or block the accounts of Polish users if the content posted in them does not violate Polish law. This seems to be a basic rule that will be subject to severe administrative penalties if breached. The proposed legal acts aims to fill the already indicated legal gap. This is clearly confirmed by the Polish Ministry of Justice, stating that currently website administrators independently makes decision about deleting entire and blocking user accounts, where in this situation there is no effective legal remedy. Even if the user proves that he or she has not broken any law and the operation of the websites violates freedom of expression. For example, pursuant to Article 1 of draft law, the purpose of this document is inter alia, of course, to create condition for 1, supporting the freedom of expression, 2, improving the level of protection of human rights and freedom in social networking websites, and 3, the observance by social networking websites of the freedom of expression, obtain information, disseminate information, express religious and philosophical beliefs, and of course, freedom of communication. Draft law provides for a number of regulations aimed at achieving this goal. Ladies and gentlemen, the material scope of the draft law is extremely wide. This is in fact about regulating that are to be applied in practice to the functionality of the essential part of the internet. It seems that for this reason, the appointment of an appropriate public body, public administration body, is an inevitable consequence of adopting draft law. Therefore, draft law provides for the establishment of the Freedom of Speech Council, which aims to uphold the freedom of expression, obtaining information and disseminating information, expressing religious, philosophical beliefs, and freedom of communication. It is meant to be a key public administration body that can be understood in terms of a control mechanism to ensure that draft law will be applied in practice. And now, ladies and gentlemen, certainly the fact that draft law is proposed for adoption in Poland should be assessed very positively, in my opinion. We lawyers, scientists, practitioners are not allowed to deny the dangers of currently perceptible technological, or civilization progress. We are talking about a simple causal relationship. Since a new level of human activity, for example, appeared in the form of cyberspace, we must be aware that there is also a phenomena of cybercrime. As the phenomena of cybercrime appears, let's introduce legal relations regarding electronic evidence and technologically advanced evidence activities. It is exactly the same with the issue of censorship. Since the internet appears as a new and more common space of human activity, we must be aware that there are also numerous threats to the right and freedoms of an individual. Internet censorship is such a threat. Since there is a phenomena of censorship on the internet, we must be aware of it and be able to distinguish between legally justified and unlawful censorship. Since we can see and understand unlawful censorship on the internet, we counteract the issuance of a law such as the draft law in Poland. And now, ladies and gentlemen, referring to the quality of the proposed draft law, it should be noted that this law deserves high praise. The regulation is understandable, transparent, and in principle, unconditional. Thus, not only the lawyers will understand the proposed principles of freedom of speech on the internet, but also its ordinary users. This is what the law should be first about. Secondly, it is worth emphasizing that all through this provision have not yet had the opportunity to be tested in practice, but it seems to be appropriate and justified. Appropriate, that is, it do not go beyond what is necessary and protect what is necessary. For example, the administrative penalties ranges from 20,000 zlotych to 20 million zlotych. That is a big difference, as the variety of digital platforms, social media on the internet is. Draft law protect individual freedoms and rights. Draft law protect individual freedom and rights, which in themselves emphasize the need for protection, and in turn to justify that is it responds to the actually occurring phenomenon of unlawful censorship, which must be counteracted in accordance with the essence of the right and freedoms of every human being, universally recognized in all civilized countries of the modern world. The legal norms containing in the draft law filling the regulatory gap, as well as have the feature of systematic compliance with the other legal acts binding in Poland. It seems that there is no contradiction or logical inconsistency between them, in particular due to the fact that draft law adjusts the wording of other laws binding in Poland. Consequently, the assessment of system compatibility is satisfactory. Ultimately, the axiology of law is also important. Draft law is an equitable law based on the principle of justice, including social justice, striving to implement the value of truth, taking into account the dignity of every human being, which is the source of his or her rights or freedoms, and introducing justified control on the internet. Ladies and gentlemen, to sum up, draft law proposed by the Polish Ministry of Justice consists a number of provisions protecting freedom of expression in internet against unlawful censorship on the internet. The assessment of this law, taking into account all previous considerations, is very high. This law is Poland's response to unlawful censorship on the internet and may serve as a model for imitation or inspiration for other countries, not only in Europe, but in general. Ladies and gentlemen, the protection of freedom of expression and pluralism that is the fact on the internet is a new goal in law for the contemporary legislator. It is a chance to maintain the standards of human rights protection developed over the years in the real world, keeping them in the digital world. For progress cannot mean forgetting the values, ideals, or principles of human universally recognized by civilized nations and natural law. If it does, it is not real progress. Ladies and gentlemen, thank you very much for your attention, and thank you very much.
So Bartek, thank you very much for your speech.